Hello, I'm Paul Kaufman. I'm a member of the Pennsylvania Bar Association State Mock Trial Executive Committee and one of the problem authors for the 2016 case. I'm coming to you now from the Community College of Philadelphia's Emmy-nominated CCP TV studio and from the Fox Rothschild Center for Law and Society at the Community College of Philadelphia. We want to thank both institutions for hosting us here today. I'm going to talk now, very briefly, about the rules of evidence. This video is intended for newer teachers who are trying to get their hands around the rules of evidence and as a refresher for more experienced teachers. I want to emphasize, evidence is a class that takes at least an entire semester in law school, and I'm going to try to do it in about 5 minutes. So this will be very, very summary. There are essentially 3 categories of evidence that are at issue when you hear an objection, Your Honor, from one of your students. With some very small variation, one of 3 things will be argued. 1, that it's irrelevant. 2, that it's improper character evidence. Or 3, that it is hearsay. Let's start with relevance. Pursuant to Rule 401, relevant evidence is something that makes a fact at issue more or less likely. So it has to be going to a topic that the case is about. That's what a fact at issue is. And it has to be something that actually impacts on whether that fact is more or less likely. So long as it does one of those things, it is considered relevant. Or, in another legal word, probative. So probative and relevant basically mean the same thing. Okay? Now, that's relevance at the baseline. There are certain kinds of evidence that the rules make irrelevant as a matter of law, even though they might be relevant as a matter of logic. And if you want to start to learn all of the rules about what relevance is and isn't, when it does and doesn't come in, you want to look in the 400 series, 401, 402, 403, and so forth. Now let's talk briefly about character evidence. The law has a really challenging relationship with character evidence. Because on the one hand, our common experience suggests that someone's character is very important for how they behave, whether they can be believed, and the like. On the other hand, the law very strongly believes that each case should be tried on its own merits, each person considered on the merits of their actions in that case, and that we should not hold against people what they did before. So you will see a very complicated and tricky set of rules, spreading principally in the 600 series, 601, 602, and so forth, about character evidence. The most important rules of character evidence for mock trial purposes are probably 608 and 609. 608, in broad terms, deals with times that you were less than truthful before, or did something bad before that didn't rise to the level of a crime. 609 represents a felony presumption that goes all the way back to the common law of Britain, that someone who is a felon, that is, who committed a serious crime, shouldn't be believable, that they don't respect the law, and therefore they may not respect the oath or the duty to tell the truth. So we take felons and we say, you can still testify, you can still bear witness in our courts, but if your felony was relatively recent or was a crime of dishonesty, we're going to let the jury know that because we think that that's important for them to know. The other area of character evidence, and it's very common in mock trial, is prior bad acts evidence, which you will find in Federal Rule of Evidence 404B. And that's the rule that says if you're in a trial for dealing drugs, the fact that you're a drug dealer before doesn't necessarily come in. And the fact that you're a bank robber also doesn't necessarily come in. The jury is supposed to hear just the things about this case. But that rule is undercut by a series of exceptions that some people would say swallow the rule. This is an area you're going to want to discuss carefully with your attorney coaches. Speaking of which, we get to the mother of all evidence rules, hearsay. And hearsay is a very complicated rule. but it comes from the simple proposition that we all follow in our life, which is that if someone tells us something that somebody else said about something else, we don't necessarily believe that. It's hearsay. It's whisper down the lane. You don't know if the message was garbled. You don't know if the person there really had an opportunity to perceive the event. So statements that are made out of court are typically not admitted to prove the truth of the matter asserted. So if I want to come in and be the witness and I want to say, well, David told me that the red car ran the red light, generally speaking, the law will not let me do that, because you have an opportunity on the other side, or should have an opportunity, to cross-examine David, to make sure David is telling the truth. He's not just the red car driver's enemy. He's not just the green car driver's friend. And that he actually saw what he says he saw. There's a lot of times that you may not know. Maybe David wears glasses but wasn't wearing them that day. Maybe David's colorblind. These are the kinds of questions that cross-examination would be designed to elicit. Now, with that said, hearsay is shot through with even more exceptions than character evidence. And those exceptions are found in the bottom part of Rule 801, particularly in Section 801D, and in the hearsay exceptions found in Rule 803, particularly 803.1 through 803.6. This is a complex issue on which weeks and weeks of attention are devoted, and many practicing attorneys still get it wrong. You should consult with your attorney coach on hearsay issues. Finally, let me close by saying this. I was taught evidence in law school by a very smart person who told us at the beginning of class that there was only one rule of evidence. And that rule of evidence was Rule 403, which says that evidence will be admitted if its probative value is not outweighed by the danger of unfair prejudice. And he said basically all of the rules just come down to that principle. If something is reliable, if we have a good reason to believe it, we believe it and we let it in. And that's what explains every hearsay exception. I'll leave it to you to determine if that is right. But I will remind you, Rule 403 does apply regardless of every other rule. And so you always need to be thinking, is this evidence unfair in some way? And if it is it unfair in a way that outweighs the value that that evidence holds? Well, that was evidence in about 5 minutes. If you have questions about this, good. You should. It's a law school class. It's tested on bar examinations, and every lawyer is at least a little familiar with it. Consult with your attorney coach, and you will be just fine. Thank you.